really quick over. Thanks, Luann. I'll just give a really quick overview. So we used to be CASA. You all used to refer to us as CASA, Court-Appointed Special Advocates. We had a number of our local programs, probably about 5, 6, gosh, it's almost 7 years ago, that broke away from the national organization for a whole bunch of reasons that just fall under like nonprofit drama land types of things. But like, so that, and because CASA is a registered trademark, we had to change our name. We couldn't use the name CASA anymore. So some of the programs still called themselves CASA. They got permission from National CASA to do that. But then a lot of our programs adopted the name Child Advocates. You may also hear Guardians Ad Litem. You may also hear Volunteer Guardians Ad Litem. If you're in Thurston County, you may hear Dependency Guardian Ad Litem. I can't keep track of all the names anymore, so just say, well, my advocate or something like that if you're referring to your own. But that change also happened during the pandemic, so it's not like we could all get together in a room and say, okay, this is what we're going to call ourselves. Everybody kind of went their own direction, and the genie was already out of the bottle at that point. But I am here to talk about volunteer guardians ad litem, staff guardians ad litem, basically anybody that serves as a guardian ad litem in these dependency cases. And just a little bit about kind of where we are. So this is our new-ish logo. So if you've seen that, that's kind of our one that replaced the CASA logo. Couple of things just about the network and how widespread we are. There are 34, that probably doesn't add up to 34, but there are about 34 programs across Washington State. We've got programs in one form of it or another in almost all the counties except Pacific and Wahkiakum and Adams and Lincoln. Everyone else has either a staff guardian ad litem program or a volunteer guardian ad litem program. And not only that, we're also on 3 tribal reservations. We have we work with the Kalispel tribe, we work with the Yakima Nation, and we also work with the Jamestown, Port Gamble, Sklallam tribe as well. Most of our programs are administered through the local juvenile court. They have offices in the court. They report to the juvenile court administrator. So they're all county court based. We have a couple of programs that are nonprofits. Clark and Cowlitz, they're a nonprofit. Trying to think who else. Grace Harbor is a nonprofit. Kittitas and Chelan Douglas are nonprofits. And basically what their role is they have a contract, and that's the only thing they do is provide guardian ad litem services. It's just rather than be funded through the court, they are actually able to go out there their own standalone 501c3 to do this work. So, yeah. Everybody else, all the other ones are all county based. So they're all county employees. So what do we do? As child advocates, our primary duty is to speak for the best interests of abused and neglected children who are involved in the dependency court system. We are assigned, the programs are assigned at that initial, whenever that dependency petition is filed and at that initial shelter care. What happens is on that actual shelter care order that comes out of that first hearing, the court checks a box that says assign an advocate or assign the program. That then goes to our local programs or the local program in the county that they're at. And then if they've got a volunteer, they'll assign a volunteer. If they've got a staff person, it really varies county to county. I'm happy to go into the details of each of your individual counties if you've got questions about that, what that looks like. It does look different from county to county. And I'm sorry about that, but it's just the nature of kind of we've never been fully funded. And so it's just a matter of, having enough money to either have staff to represent these kids as guardians ad litem or volunteers. And it's just a hodgepodge. One of the other roles that we have is to be the eyes and ears of the court. And we take that role very seriously. What we really like to do, and we've had judges tell us this before, but judges will tell us that They only see about this much of the case. And what they really want our advocates to do, guardians ad litem to do, is to help expand their view of what's going on, because we are an independent party, right? The parents, they have attorneys, they have their own thing that they want to do. The state and the DCYF social worker, they have things that they want to do. Each one of them are trying to tell their own narrative about what they think should be happening with the case. Our role is to provide that additional kind of like context for the court so that they get that unbiased, unfiltered kind of other independent investigation of what's going on with these cases as well. So it's just another set of eyes and ears. And I'll also draw to your attention, please notice it says eyes and ears. We are not the hands and feet. We'd like to tell that, we remind that to the judges as well. Like, we're here to provide the court additional information, confirm information, but we're not here to we don't supervise visits. We don't transport kids. That's not what our role is. It is to be the eyes and ears of the court. We also encourage our advocates to advocate for a return home as quickly as possible when it is safe to do so. And this is something that we've been putting a lot more emphasis on lately too, is safety should be paramount, right? At the basis of any kind of return home, any kind of return determination. But we've also found too that sometimes kids stay in foster care when they could have gone home a little bit sooner. And what I mean by that, I'm not saying file the dependency and then put them back home the next day. But there are times where we've got a parent that's engaging in services. They're doing really well. They are a different person than when they came into this system, when that dependency petition was filed, versus where they are 6 months, 9 months, or even a year from now. And hopefully, if it's safe, maybe we can do an earlier, put the kid and the family back together sooner, even while mom, even while dad are still working on stuff and still kind of completing all the stuff that they need to do. If it's safe, we really want to see the kids go home, because the longer we leave kids in out-of-home care, the more disruptive it comes for them, the more disruptive it becomes. And that's where we really start to see really bad outcomes for kids in foster care happening. So that's kind of one of our other things that we're pushing out there too. We make independent recommendations. So our advocates and our volunteers are trained to make independent recommendations based on their gathering of facts and the information that they gather. So it's not uncommon sometimes for folks to go to court and, you've got the parents making one set of recommendations. There are things that they want to see happen. You'll have the state and the AG's office saying that something that they want to see happen. And then you'll even have an advocate coming in and saying, here's option number 3, or here's something else that needs to be considered as well. We are full parties to the case, and so we get to make recommendations as well, regarding the best interests of the child. And then finally, we expect them to be advocates, right? We expect them to do the work. We expect them to show up. We expect them to talk to you. We expect them to talk to the care or other family members. We expect them to talk to the parents. We expect them to talk to everyone and actively advocate for the child while they're under court observation or in court process. Luann, I am not used to just running straight through. So I like asking people having questions beforehand, but I understand that you want to keep that separate.
Nope, it's fine. It's up to you. Go ahead.
Anybody have any questions so far? Thank you. Okay. I'll keep going then. We have some statutory duties. So this is what it says in the law, and all of our laws governing the duties of a guardian ad litem are in 1334-105. To represent and be an advocate for the best interests of the child. If we have time, I'll show you how we kind of make some of those analyses when it comes to best interests. Our other duties include to investigate, collect relevant information about the child's situation, and report to the court the factual information regarding the best interests of the child. We need to be fact-based. That's how we draw our recommendations from the information that we gather, not based on our opinion or what we should think happened with the case. We are also statutorily mandated to monitor all court orders for compliance and bring to the court's attention any change in the circumstances that may require a modification of the court's order. So this is part of that being a party, right? We can go to the court and say, hey, things have changed. This needs to happen instead, or this is the direction that we need to go. One of our other duties is to report to the court information on the legal status of a child's membership in any Indian tribe or band. So that's one of the things that we're looking at right from the beginning. Is this child Native American, and does ICWA apply? We also make recommendations based upon our independent investigation regarding the best interests of the child, which the court may consider and weigh in conjunction with the recommendations of all the parties. We are not the final arbiters of what's in a child's best interests. We gather information and make recommendations, what we think or what we believe the facts indicate is in the best interest of the child. But ultimately, it is up to the judge to decide that. It is not up to the guardian ad litem. It's not up to the CASA. It is up for the courts to determine what's in a child's best interests. And then finally, we're also deemed an officer of the court. Some of the other things, we have access to information. The guardian ad litem shall have access to all information available to the state or agency in the case. We also get access to information from hospitals, any agency, division, or department of the state, doctor, nurse, or other healthcare providers, psychiatrist, psychologist, police, or mental health clinic. We're allowed to have access to their records. If the kid's under 13, we don't even need the kid's permission or the parents' permission. If the kid's over 13, we would need the child's permission. Just like you guys all know that too, right? Like if you've got a kid that's over 13, they've got to sign their own thing saying to give you as their caregiver permission to access their medical records or records of that nature. So we have access to a lot of information. So again, our role, gathering info. So we're going to review records. We're going to gather information from other parties. One of the things that, we really predicate ourselves on are making sure that we see the kid. We tell our volunteers our expectation is for them to go and visit the child every 30 days. We also ask them to see the kid in a variety of settings. So they're not just leaning on, you as caregivers, but maybe if they're in school, maybe figuring out a way that they can meet with the kid before or after school, or at daycare providers. It's just so that we can get a better picture and present to the court kind of, how this kid is showing up in these different things. And then we also require our advocates to submit a written report, and part of that report will also include their recommendations of what should be happening in the case. We also ask our advocates to facilitate conversations that need to happen, right? So they're kind of that based on what's in the best interest of the kid. So that might be saying, hey, I think we need an FTDM, or hey, I think we need a shared planning meeting, or basically we all need to get together and figure out what's going on here, and kind of helping to facilitate best interest of the child decisions and actions that folks need to take as well. We expect them to advocate for the child's needs. So this is where we're going to be asking, we'll probably be asking you as caregivers, like, hey, does the kid need anything? Do you need anything? How can we get that information in front of the court so that the court can make those rulings or make those orders for things that the kid may need? And then, like I said earlier, we also monitor the case, make sure things are happening in the way that they're supposed to be happening. We do have the ability, like I said earlier, to file a motion and let the court know, hey, somebody's not doing something that they said that they needed to do, so that we can get these cases going faster, making sure everybody's got what they need. Questions on these points?
Not on these points so much, but Tim is wondering over in the chat section if you may be answering what the qualifications are to be a CASA.
Yes, I'll get to that.
I have a quick question about the every 30 days. Is that a recommend?
Yes.
Well, I have a couple of questions about that. Is that a recommendation or a requirement? And are they required to let somebody know when they're going to show up? Like, or can they just kind of appear at a visit or appear at a doctor's appointment? Um,
Thank you. Great questions. So we fully expect the volunteers to visit the kid every 30 days. Staff GALs, depending on how busy they are and kind of what the court's expectations of them are, that might differ. Ariana, what county are you in?
we're in delightful King County. Our CASA
The
is a
other thing,
volunteer.
okay, yeah, so they should be making contact with that kid every 30 days. To your question about can they just show up? We tell them no. That they need to be planned. You guys are too busy. And the other thing that we're really trying to convey to them, we're not here to catch people doing something wrong. That is not our role. We sometimes have advocates that, they like to get their deputy dog hat on and we try to weed those guys out. But we tell them there should be no unannounced home visits, not even if they're just dropping something off. And if you get something like where they are doing, we tell them, like, schedule your meetings in advance, especially when you're meeting with you. You guys are busy. You're taking care of kids, right? Like, so call them up and say, hey, sometime in the next couple of weeks, is it possible that I could come out and just spend and this is the other issue that you guys come up with too. Maybe that initial meeting that they have with the kid, that might be like 45 minutes or an hour, right? They're just trying to figure everything out, introducing themselves to you and all that. But after that, I mean, we're really talking like 20, 30 minutes maybe, right? Like just kind of getting in there, getting an update on where things are, and then leaving. So if that's not what's happening in your case, please call the program and express your concern so that we can have a counseling session with that advocate. So a couple of things that we do not. We do not provide services, right? We're just gatherers of information. We do not act as a big brother or a big sister. We are not this kid's mentor, right? We're not spending enough time with them to establish that type of relationship. There are other programs out there that do a very good job of this. That's not our job. We don't provide transportation for the kid. We do not give the child gifts. Now, like, there's some of the programs have very small little exceptions to that, like maybe like a coloring book. We tell them like under $5, but that was before inflation. So I don't know what the limit is now, but it used to be, like a little something. But like, and really, we really have even been discouraging that because we don't want this to look like, we don't want the child to think, oh my gosh, every time this person sees me, they give me a present. So then that's not what we're trying to do, right? So we don't give the kid gifts. We don't supervise visitation. We will observe them sometimes, but we do not supervise. And then the last piece is we don't take sides. We are to remain independent throughout the course. And I'm not going to have time to go over these two. But with that, with that taking sides piece too, I am going to drop in the chat so that you guys have it. So those were the things that I just went over before. Those are statutory duties. We also have court rules that we have to follow. And I will put these in the chat so that you have them. And then I'll pull them up really quickly too, just so you can see what we've got here. So these are the guardian ad litem rules, or you'll hear them referred to as the GALRs from our people. But these are all court rules that all of the volunteers have to follow as well. So representing best interests, maintaining independence, professional conduct, remaining qualified to be a volunteer, conflicts of interest. We spend a lot of time on that one. Treating parties with respect. They need to be informed about their cases. They can't do evaluations. Only professionals can do evaluations. They can make recommendations for evaluations, but you should never hear a GAL say, so-and-so needs to do this. Like, that's not our role. We go to the court and say, hey, we think it would be a good idea if this child was evaluated for something, but it's not our role to diagnose. Timely inform the court of relevant information. Like I said, we can file motions. We can also let the court know what's going on in a case if something needs to change. We're only allowed to do what the court tells us to do. And the only people that can tell us what to do are the court or their program. We tell this to all the volunteers. The only person that can tell you to do something is the court and your supervisor. That's it. They should let you know about their role in the case, kind of what that looks like, kind of what a guardian ad litem is. We actually spend some time in the training basically having folks role playing, introducing themselves. They should be going to hearings. They are not allowed to talk to the judge directly. They've got to go through the court process. We also expect them to maintain privacy, confidentiality. We spend a lot of time on confidentiality. They're supposed to do their duties timely. They're supposed to maintain documentation, and they're supposed to keep track of their time and expenses spent. So I put that in the chat just so you can see kind of, so these are all these other court rules that the volunteers have to follow as well. And we spend a lot of time in training going over these as well. So we've got statutory stuff, we've got court stuff. Some of the programs have their own rules that they put on the volunteers as well. So it's a pretty well-regulated group. We have a lot of rules guiding our practice. Questions while I'm swapping back over to the PowerPoint?
I had a quick question. I was wondering that, and I stepped away for a minute, so I might have missed it in one of the earlier slides. But you know, this last one, keep records of time and expenses. The expenses make sense, but with the time, this is a volunteer position, correct? So
Correct.
why the time, I guess, is my question.
So we can go to the legislature and the county funders and say, look how many volunteer hours these people have given up for free to provide these services. That's a big one. The other reason, Monica, is that some of our volunteers are covered by county liability pools. And in order for them to be covered as like, quote unquote, an employee, so that if they ever got sued or got injured on the job, one of the ways that the insurance companies accept them as being part of that pool is if they submit the hours that they've worked.
Okay, that makes sense. Thank you.
Yep. It's also the way that we make sure that when we ask them for their timesheets, it's also the way that we check in and make sure, are you doing the work that you need to be doing, guys? Right? Because that's the other piece of it too. We do kind of give the volunteers a lot of free reign, but like when they're coming in and saying, yeah, I did 2 hours this month, like that's probably not enough to be an effective advocate. We tell them anywhere between 5 and 10 hours, and probably more at the beginning stages of a case when things are really fast moving. Okay. So what do you have to do to become a volunteer? I'll be honest with you guys, the statute's really, really vague. But virtually all of our programs will say 21 and over. You got to be 21 and over, and you got to be able to pass a background check. Other than that, like that's kind of where it stops statutorily. So they all have to get fingerprinted. They all have to do all that stuff. But beyond that, there's like no education requirements other than you have to go through this 30-hour training. That is statutorily mandated. That they have to go through 30 hours of training in order to do this work as a volunteer. There's also an ongoing service requirement that they have to be trained for an additional 12 hours per year. So basically 1 hour a month. That's why sometimes you guys will have our advocates showing up at some of these Carers Alliance things because they're trying to get their training hours in. So that's another reason why too. And then they are also, all of the volunteers and even all the staff, they all have supervisors, right? Like it's not like they're free agents just out there doing whatever they want to do. No, they all have supervisors that they are in contact with and helping them understand the intricacies of the child welfare system. The screening process varies from county to county. And by and large, just so you all know, I am training now most of the new advocates as they come through. I train all of the only counties where I'm not training the volunteers are King, Snohomish, Chelan and Douglas, which is Wenatchee, and that's it. And even King County, just they're starting to send folks through our training as well too. So I say that because part of one of my duties is I'm providing these trainings is that I will call programs and say, this person's a little Looney Tunes. I would not want them to be my child's advocate. You know what I mean? Or I don't think they would make a good advocate. Like they're bringing the wrong mindset into this work. And some of them will listen to me. Some of them don't. Some of our programs do like a whole, like they have like a parent attorney, like they bring in a whole panel to interview these people. Some of them are just like they have a conversation one-on-one with the supervisor before they are allowed to apply for the training. So, Tim, to answer your question, there's nothing hard and fast. But we also know that a bad volunteer can cause a lot of damage and do a lot of harm. And it only takes one or two of those bad volunteers before our program staff and our program managers are like, I need to start screening my volunteers better because it is just a huge headache to try to reel that and put that back into reel that back in after it's already been kind of messed up. One of the benefits of being a GAL and kind of our program is like, we're not the department, right? So in a lot of ways, if it's not in statute or if not in court rules, we get to make up our own rules. And so there's pluses and minuses to that, right? Like the department's got that huge, thick policy procedure manuals that they have to do every time that they do anything. We don't, but there's pluses and minuses to both of that. So sometimes we get people that are a little bit, anyway, you know where I'm going with this. Tim, did that answer your question? I hope so.
He gave a thumbs up.
Oh, good. I didn't see that. Good. Okay, perfect. Okay, communication. This is probably one of the more frustrating aspects for you guys, I would think. We train our advocates and our GALs that they cannot share case information about the case with any non-parties. And caregivers are non-parties. We are not allowed as advocates, and this goes for staff or volunteers, anyone, we can't tell you how mom's doing. We can't tell you if mom's going to treatment. Like that is, it's confidentiality. We cannot release that information. And so it may be frustrating for you because you're like, I know you know the answer, GAL or CASA. I know you can tell me what's going on. They can't because of confidentiality rules. And in fact, we train them. The best, we tell them, you should not be making statements, advocates. Like you should not be saying anything. The only thing that you should be doing is asking questions. If you don't want to get in trouble doing your role, just ask questions. Don't make statements. We can't share information with you. Even about the child. Like if we know that the child, maybe the child has an allergy or something like that, by statute and by court rules, we can't share that information with you, even if we know it. And even if we think it's in the best interest of the child, we can't do it. We have to tell that's why you'll often hear, ask the social worker, right? You're going to have to talk to the social worker. Or if a GAL tells you, you really should talk to the social worker about this kid's case or this kid's medical information or things that happen with this, the social worker can talk to you. We cannot. We also, and so with that too, you guys are going to know a lot more about these kids sometimes, especially the day-to-day stuff and kind of what's going on with them. We would ask that if something important is happening or changes are happening with that kid, I know you need to let the social worker know, and social workers are generally pretty good about letting us know as well, but you guys know there's good social workers out there and bad social workers. We run into the same thing. But if there are things that are happening to that kid, if you could just call or even just send a shoot or even CC us on the email that you would send to the social worker about things like school or daycare changes, disruptions or changes to the child's schedule or routine. Part of the other thing that we're really starting to look at too and think about is what's your availability to be a resource to other caregivers, including the parents. The other thing that we're really starting to push to is thinking of ways that I'll just say it like this, co-parenting opportunities between you and the child's parents. One of the things that we really are trying to get away from is only using visitations as a way to assess how a parent is able to parent a child. You guys all know that visits are not parenting, right? You put the parent and the kid in a room together. Usually they're supervised. You got somebody there. That's not parenting. It's not. So one of the ways that we're trying to expand this idea of what it means to parent a child is to give them opportunities to parent or co-parent. Like saying, hey, the kid's got a doctor's appointment coming up. It'd be great if you could go. It's at 9:30. Here's the address. That's parenting. Parenting is going and showing up, and you guys know this, but right? Like it's doing the stuff that you don't want to do, but you have to do because you're a caregiver or you're a parent. And we want to start giving parents more opportunities to engage in that kind of parenting versus just the 2 hours, 2 times a week supervised. So like thinking about if there's school events or things like that where the parent can show up, soccer games, right? That's parenting. Sitting at the sidelines, I mean, that's being a parent, right? Watching a soccer game for 2 hours on a Saturday when you've got better things that you could probably be doing with that time. But that's parenting. And so really encouraging us to find ways that we can engage the parents when it's safe, but ways that they can be engaged in co-parenting activities. Because if it's working, great. We can write a report to the court and say, they went to this doctor's appointment, they went to this, like these are the things that they're doing to parent versus, and we can also just as easily say, you know what, we gave them plenty of opportunity to show up, to be a parent, to do these things, go to the doctor visit, sit with the kid during the dentist visit, right? Like do those things, and they opted not to, right? That's parenting. But we can't assess that unless we give them the opportunities to do so. And then depending on how brave you guys are feeling too, having them set up a doctor's appointment. Or having them set up, figuring out what day, I don't know, but right, like giving them opportunities to parent, even though they don't have custody. And then finally, too, thinking about extended family opportunities. We want to add you to the child's cadre of helpful adults. But a lot of things, what we hear from kids is that they don't know who their bio family is. And so while the parents may not be able to parent, that doesn't mean that we need to cut them off from all of their family. Right. And so figuring out ways that we can and being listening for, and this is where we could use your help, but like we really encourage them to listen to like maybe grandma and grandpa are having an anniversary party, or maybe they do dinners every Saturday, right? Like giving them the opportunity to be with their extended biological family as well, not just mom or dad. How are we doing so far, guys? How's that landing? This is like new child welfare stuff. All right. So again, regularly sharing information about the child's placement, services, school, medical and mental health issues, status and progress. And then we also encourage you to share with your child's advocate specific recommendations or suggestions and findings that will be included in that could be included in their court reports prior to submitting to the court when possible. How many of you guys do caregiver reports? How many of you are aware of caregiver reports? So you all, as caregivers, have the opportunity to write a caregiver report that the court can review and see and look at. As part of that, and you can give that to the advocate, you can give that to the social worker, but we can make sure that that gets before the court so that they see it and kind of what you're seeing as well. Courts really like to look at that too. Kind of see how the kid's doing in placement. Good. Sonia?
Yes.
You unmuted. Did you have a question?
No, sorry. I'm just trying to put it back on. Sorry.
No problem. Yeah, and I'm sure Luann can follow up with you all about the caregiver report, kind of what that looks like and how to get that before the court. But that is another way that we can get information to the court so that they know what's going on.
Can I just ask for a quick clarification? I do
Sure.
my caregiver reports and I submit those directly to the court because I got the email telling me to do that.
Great.
But I guess I assumed that the CASA would then get a copy of it. But are you saying that I should just send her a copy directly instead of waiting for
No,
the?
if you send it to the court, we'll get it. It'll get distributed to all the parties. So if you do that, that's great.
Okay, thank you for clarifying.
Yeah. If you just send it to the social worker, you might want to also try sending it to the advocate as well, so that way we make sure it gets to the people that it need to get to.
I learned a while ago to never ever send something to only the social worker.
That's why I just said what I just said, Ariana. Thank you. So, all right. I want to talk a little bit about best interests and kind of how we approach best interests and how we train our advocates to think of best interests, because I think a lot of people are confused by what. Oh, thank you, Luann. I think a lot of people are confused about what best interest means. And this is one of those things too, where we've had to take it back because we've learned over the years too, that we have advocates who think that because this is the way they raise their child, this is the way all children should be raised. And that is not helpful. Most of our volunteers, although we're getting a lot better at this, I used to joke that our volunteers were old white grandmas, right? Like that could afford to do this. Our volunteer base is actually getting a little bit more diverse. Like we've got younger people that are stepping forward and doing this. It's still mostly women, but we do have some men that have been going through the training. And many of our volunteers are coming at this work through a lens of privilege, right? Like it's a privilege to be able to volunteer. You've got enough time and resources that you can freely give your time. And so this idea that they were the arbiters of what good parenting is, and we've had to stop that. It was gross, to be honest. So we've really sat down and thought about, okay, what does best interest of a child mean? What should we be telling the court? How do we define that? So these next couple of slides are actually from our training, what we use to train volunteers on, about how to think about best interests. Oh, I forgot a slide. That's okay. So we break up best interests into 3 domains: permanency, safety, and well-being. I'm sure you guys have heard that at some point, like that's why we're here. This is what we're trying to do by kids: permanency, safety, and well-being. We took those 3 domains and organized them. And if you think about it, permanency, safety, and well-being really corresponds pretty nicely with Maslow's hierarchy of needs for a kid. So at the very bottom, you've got physiological needs, right? Food, water, warmth, rest. Next level up, you've got safety and security. So those kind of fall under that safety domain, right? This is kids need these things to be successful. Up, as we go a little bit further up, these are where we get into the permanence and well-being aspects. So belongingness and love needs, intimate relationships, friends. A big one that I think is missing from this particular model is family, kind of knowing who you are and where you come from. That's also in this like belongingness and love needs. Who is your family? Esteem needs, prestige and feeling of accomplishment. And then, so that kind of falls under well-being, self-actualization and achieving one's full potential, including creative activities. Sometimes adults don't even get that high, but this idea of that also falls into well-being. And so what we have been training our advocates in recently too, and thinking in terms of best interest, or even just how to approach this case, is thinking about Maslow's hierarchy, right? If a kid doesn't know where they're going to be sleeping tomorrow night, they're not going to care about the piano lessons that you're getting them, right? If they are worried about their parent, like it's really using Maslow's hierarchy as a context for the work and figuring out where can I as an advocate be effective in terms of what this kid needs and not jumping all over the place. The other thing that we use too, this is the next slide deck. This is also how we talk about best interest too. This actually came as a shock to me as we were developing our new curriculum about 5 years ago. I thought as I was putting best interest, all right, I'm going to train on best interests. I'm going to train these volunteers what it means to be best interests. And I thought I'll just type this into Google and Google will give me all the answers and all the scholarly articles I need to know about what's in a child's best interests. I will have the definitive answer of what's in a child's best interests to be able to train our volunteers on that. And you know what I found out really quickly? There is no universal standard or definition of a child's best interest. In fact, there has been Washington Supreme Court cases where they were asked, please clearly define and delineate what's in a child's best interests. And the court has said, nope, we're not going to do that. Because it changes and it's different. As I train my advocates, parenting practices change from generation to generation. What we once considered in a child's best interest or ways that, we can ways to even just raise a child have completely changed from generation to generation. Probably has been for generations before that. I only know my parents, their parents, you know what I mean? But this idea of like what's in a child's best interest, it used to be a good example, corporal punishment. How many of you were raised saying that with a parent who said, if you act bad, I'm going to spank you. How many of you got spanked? That's completely gone now. And that's this idea of best interest, right? It's evolving. And what may be in one kid's best interest is different than what's in another child's best interest. There are, however, some guidelines. The thing that we are trying to see achieved in this whole dependency thing is parent-child reunification. How can we get the parents, how can we help the parents so that they can get the kids back? That's why we do what we do. Best interest is also not the same thing best interest is not the same thing as what the kid wants or wishes to see happen. This is where we get into some little turf wars sometimes with attorneys, right? Kids attorneys that come in and say, I'm here to advocate for what the kid wants. I will just say this. If a kid told an attorney, I would like birthday cake for breakfast every morning, the kid's attorney would be professionally obligated to present an argument to the court as to why their client should get birthday cake for breakfast every morning. Best interest, on the other hand, can say, we're required as advocates to report what the kid wants, but then we can also say, and here's why this would not be in the child's best interests. Attorneys can't say that. Now, I know that's a really basic example, but just play that out as, kids ask for the darndest things, right? And they're not always acting. Kids aren't always acting in their own best interests. You could probably get me whole started about how we've in an effort to make sure that kids are heard, we've adultified them. I don't know if that's the right word. A little bit too much in dependency, asking them to make decisions about who do you want to live with? Do you want to go to visit? Like that. There are some things that kids shouldn't be asked. That's parents' job, not the kids. But in dependency, it's a whole other thing. But anyway, I digress. And I'll just say one more thing about that. I've raised a 14-year-old. There is no way in hell I would want my 14-year-old to have their own attorney to tell me what I need to do to better parent them. But that's the system that we're creating or have created. I don't know that that makes sense. In cases where the Indian Child Welfare Act applies, it is always in the Indian child's best interest for the tribe to make best interest decisions. So if kid is native and ICWA applies, the tribe gets to call the best interest shots. We can influence them, we can talk to them and kind of bring our perspective, but ultimately at the end of the day, that child belongs to the tribe and the tribe belongs to the child. And so it becomes up to them. And then finally, and probably most importantly, it is not the advocate's personal best interest beliefs either. So the way that we combat this and think about this is another tool that we have. We call this our best interest tool kit. It's really just a series of questions. But so I tell them, and let me put this in the chat really quickly too for you all. So whenever I get a volunteer or a staff person who gets stuck on what's in this child's best interests, this is what I give them. And then we have a conversation about this. So before I launch into this best interest toolkit thing, first of all, I'll just tell you what I tell them. The series of questions to consider when baking best interests is not all inclusive. There's probably other things that we could have added to this, but we kept it pretty brief. It's also meant to scale from should we increase visits from 2 hours to 3 hours all the way up to should we reunify? Before sitting down to use this tool, we ask folks to get clarity on the question you're asking it. Use it like a magic 8 ball. It can only answer the question in front of it. It cannot tell you what's in this child's best interest unless you ask it a good question. And then finally, and this is really important for our linear thinkers, I tell them this is not a scorecard. This is not a BuzzFeed quiz that you just click all the answers. You count up all the yeses, all the nos, and if it's a majority yes, it must be in the child's best interest. That's not how this works. It's designed to help you think about all aspects of best interest and kind of help loosen things up a little bit in your mind. So I'll go through this with you really quickly so that you can think about how we approach best interest advocacy. The first one, and we break it up into the 3 domains as well. So the first one is safety, and it's really easy. Is the proposed decision safe for the child? And we don't do this here, but Luann, I would be happy to come back at some point and talk about the safety framework that we train the volunteers and the court staff, everybody uses. That's one of my other side gigs, to show how the court looks at safety and how they analyze safety. It's from the American Bar Association, but it's a whole framework. Basically, it tells you what's the threat, is the kid vulnerable to that threat, and is there any protective capacities we can put in place to keep the kid safe. But that is a whole other 2-hour training. So when we think about timely permanence or just permanence, these are the questions. Will the proposed decision lead to a greater chance of permanency for the child? How so? Will the proposed decision lead to permanence in a more timely manner? How or why? Has enough time elapsed from the start of services to now that allows for a demonstrable impact of their effect? Basically, have we given the services enough time to cook? What will the impact of this decision look like 5 or 10 years from now for the child? What about when the child becomes an adolescent? What about when they become an adult? Well-being. Does the child agree with your proposed position? How do you know? Will the proposed decision lead to an increased sense of family for the child? Not a family, his or her own sense of family. Will the proposed decision develop and or maintain supportive connections for the child? How and who? Do members of the child's biological family support this proposed decision? How do you know? Do members of the child's professional team, therapists, doctors, etc., support the proposed decision? How do you know? This next one could probably be its own questionnaire because there's a lot packed into this one. But is the proposed decision in alignment and consistent with the child's race, racial identity, cultural heritage, sexual orientation, gender identity, and religious upbringing? How are you sure? And then finally, does the proposed decision mean the least amount of transition or disruption for the child? And what we're really trying to do here, rather than just get stuck on, this is what I think should happen with this kid, is really thinking about this kid. I call it the beach ball method. Looking at this kid from all the different pieces. So if you think about each one of these questions as one of the panels in the beach ball, it helps you get a better understanding of, like, holistically kind of where you should go in thinking of best interests of the child. So when we get people that get stuck or like, I don't know what recommendations to work on, we sit down and we go through these questions together, and usually something pops up. Thoughts, questions, comments about this best interest toolkit that we give to folks? And just so you all know too, this is the other thing I train all of our new advocates. They are never to use because it's in the child's best interests at the end of any statement they're ever making. We should do this because it's in the child's best interests. That is wrong. They can say it's in the child's best interest to do X because we want them to justify how they got there. Show your work. Tell me why. Don't just say something's in the child's best interests. Tell me why. That's the important part. We don't care about what you think. How you got there. All right. Switch back here. And that's kind of it for the formal part of this training. You guys can reach out to me at any point, but is there anything else that you guys want to know?